If you've ever dealt with a homeowners association, you know it can feel, well, let's just say frustrating. It can seem like you're playing a game where the rules are a moving target. But what if you could prove it? Today, we're diving into a fascinating legal case where one homeowner did just that. He took on his HOA, he lost, and then he came back and won. And it all hinged on one piece of paper that changed absolutely everything. So this is the real head-scratcher, right? How on earth does this happen? You've got the same judge, the same set of facts, the same case, and she issues one ruling, and then later, a completely different opposite ruling. It seems impossible. But the answer, as we're about to see, lies in a crucial piece of evidence that completely flipped the script. All right, so let's set the stage. Our story centers on Tom Bars, a homeowner living in the Desert Ranch subdivision out in Scottsdale, Arizona. And like a lot of homeowners, he just wanted a better handle on what was happening in his community, specifically with the Environmental Design Committee, or EDC. So he did what any of us would do. He asked for the records. And look at how he did it. This wasn't just some casual email. He was formal, he was specific, he cited the exact state law that gave him the right to these records, and he spelled out precisely what he wanted, a full year's worth of actions, requests, and approvals. This was a totally straightforward, by-the-book request. And this is a really important point. Mr. Bars wasn't just asking nicely, he was exercising a legal right. This Arizona law is all about transparency. It says an HOA has to make its records available, and it has to give your copies within 10 business days. It's not a suggestion, it's the law. But this is where things start to go sideways. Instead of handing over the actual emails, letters, and applications that Mr. Bars asked for, the HOA just sent him a summary table. Now, a summary is nice, but it's not the real thing. It's not the detailed communication he was legally entitled to see. And that incomplete response is what kicked off this whole legal battle. So, Mr. Bars filed a petition with the state, thinking the law was clearly on his side. He goes before an administrative law judge for the first hearing, but the outcome was probably not what he was expecting. The HOA walked away with the win. So here's how the arguments broke down. It was pretty simple, really. Mr. Bars' claim was, hey, you didn't give me what I asked for, but the HOA's defense was a clever procedural one. They basically said, well, he didn't email every single person on the board, so his request wasn't submitted correctly. Therefore, we didn't have to comply. It was a total technicality, but, as we'll see, a pretty effective one. And the judge, Jenna Clark, she agreed with the HOA. This is the core of her first ruling. She said that because Mr. Bars didn't send his email to the entire board, he technically messed up the submission process. And because of that, she ruled the HOA was not in violation of the law. And just like that, the petition was denied. Tom Bars lost. You can only imagine how frustrating that must have felt. You follow the law, you make a reasonable request, and you lose on what seems like a technicality. But thankfully for him, this wasn't the end of the story. See, Mr. Bars didn't just walk away. He appealed the decision, and he was granted a rehearing. And this is where the whole mystery starts to unravel, because he came back to that second hearing with a new piece of evidence, something that was there all along, but just wasn't brought up the first time around. And the piece of evidence that flipped this whole case on its head, it wasn't some obscure legal precedent. It was simpler and way more powerful. It was written proof that the HOA itself had told him exactly who to send his request to. He wasn't guessing. He was just following their direct orders. Okay, get ready, because this is the smoking gun. Just look at this timeline. Over a year earlier, the HOA president herself put it in writing. Brian Schofler is your primary contact for records. Then, just a few months before his request, she added someone else, Lori Lockley at the management company. So fast forward to November 1st. Who does Mr. Bars email? Brian Schofler and Lori Lockley. He followed their instructions to the absolute letter. The moment that timeline hit the table, the HOA's entire defense just evaporated. It was gone. This was no longer a story about a homeowner who made a procedural error. It was now a story about an HOA that gave specific, written instructions and then tried to penalize the homeowner for, well, following them. And right here, you can see the 180-degree turn in black and white. It's night and day. The first ruling said he failed to submit the request properly. The final ruling says he had been expressly instructed to send it to the exact people he sent it to. This new evidence wasn't just a small factor, it was the entire ballgame. And so Judge Clark's final ruling was completely unequivocal. Mr. Bars had proven his case. By only providing that summary table, the HOA was in violation of state law. The homeowner won. And this one wasn't just symbolic. It had real, tangible consequences. First, the court ordered the HOA to reimburse Mr. Bars the $500 he paid just to file the case. That made him financially whole again. But then, on top of that, the judge hit the HOA with an additional $500 civil penalty for the violation. This sends a really clear message, right? Failing to follow the law actually has a cost. Now, you might be thinking, okay, that's a great story for one guy in Arizona, but what does it have to do with me? Well, the lessons from Tom Barr's fight are pretty much universal for any homeowner living with an HOA. This is basically a masterclass in how to protect your rights. So, what is the big takeaway from all this? It's actually incredibly simple. Tom Bars won because he had a paper trail. That's it. Document everything. Get all official instructions in writing. Know your rights. And remember, an initial loss doesn't have to be the end of the road. Persistence, when it's backed up by good records, is your single most powerful tool. And that really brings us to the final question, and it's one I want you to ask yourself. If you had to make an official request to your HOA tomorrow, would you be relying on something someone told you in a hallway, or do you have their instructions in an email, in writing? Because as Tom Barr's case proves, that one little detail can make all the difference in the world.